I was in court recently watching a medical malpractice trial, and over the next couple of days I had a chance to stop in and watch the rest of or parts of that trial. At the end of that case, the attorneys gave summations, known as closing arguments. The defense attorney in this malpractice case, representing the doctor, went first. And after that attorney was done, then it was the plaintiff's attorney's turn to go ahead and give his closing arguments. Now, the plaintiff gets the last word. Actually, I shouldn't say that, because after the plaintiff's attorney is done giving his closing remarks, then the judge is the one who actually gets the last word into the jury. The judge then gives instructions, legal instructions to the jury about the law that they have to follow in reaching their verdict. So let me get back for a moment to the closing arguments and the actual verdict. In this instance, I found out from other people who are watching this trial that the defense attorney was phenomenal. And I would agree, from what I saw, I would agree that the defense attorney was absolutely remarkable. He connected with the jury on such a personal level. It was remarkable to see. It was great to see. Now, I've been doing this for now 37 years. I was a defense attorney for 4 years out of my career in the very beginning. And then I've been a plaintiff's attorney representing injured patients and injured victims for the remainder up until now. And it's really something when I get an opportunity to watch someone who is excellent at what they do, regardless of which side they're on. In this particular case, the defense attorney did a phenomenal job questioning his witness, did a phenomenal job in bringing out key information so that the jury understood the facts of the case, so that the jury understood the intricate details. Because I will tell you, I also saw in this case the plaintiff's lawyer go ahead and make opening arguments. I heard the defense lawyer make opening arguments. And after listening to the plaintiff's attorney make opening arguments, I couldn't understand exactly what the issue was. I didn't understand why the plaintiff's attorney was so angry. I couldn't understand what he was talking about and where the real issue was. And that is a significant fault that led ultimately to his client's downfall. When the defense lawyer went ahead and made opening arguments, he was very clear, he was concise, he was precise. He wasn't angry, he wasn't screaming and yelling, he was just having a great conversation with the jury. And I believe, after looking back on the actual result, I believe that the jury connected with him immediately, but they never connected with the plaintiff's attorney. So now, at the end of the case, the attorneys gave their closing arguments. And I heard from a couple of people who had been watching that particular trial. He was detailed, he was considerate, he was kind, he made eye contact with the jury, and he spoke to them on their level, which is extremely important. And this was a very complicated medical malpractice case, but he made it so simple and so easy to understand that, again, I believe that he connected directly with the jury with everything that he told them. The plaintiff's attorney took it personal. The plaintiff's attorney could not get past the fact that he could not establish a great relationship with the jury. The plaintiff's attorney got very frustrated with the doctors who were involved, and his frustration showed through dramatically. His frustration prevented him from recognizing that he had a losing case. His frustration and anger came through, and he tried to take it out personally against these doctors, and it clearly showed in the result. And why do I say that? The jury is now told to go ahead and have their lunch. Lunch is being brought in by the court for them. And now, after they have done with their lunch by 2 o'clock, then to go ahead and start deliberating. I learned from people who were in the courtroom that the jury came back with a note 5 minutes later at 2:05 or approximately 2:05. And what was the note? We have a verdict. That means that they deliberated for a total of 5 minutes. By the time they now brought the attorneys back in and that they brought the judge back in, about 20 minutes had gone by. And now all the parties are back in the courtroom, and now the judge asks the jury to read the verdict. And what is the verdict? Did the doctor, the defendant doctor, violate the basic standards of medical care? Or actually, it should say, was the defendant doctor negligent? Yes or no? In this particular case, the answer by the jury was a unanimous no. Now, since there were two doctors who were being sued, the jury, instead of going on and answering other questions relating to whether or not any wrongdoing was a cause of the injuries, and if so, how much money they were to give as full and fair compensation for those injuries, they never answered those questions because they determined unanimously that the defendant doctor was not careless. So what happened then? What happened then is now they had to go to the next question regarding doctor number 2. And the question was doctor number 2 negligent? Yes or no? And again, the jury unanimously decided, no, the doctor was not negligent. And in that instance, in that case, what happened? The case is over. Absolutely over. 5 minutes. This is remarkable for a medical malpractice case. And you know what that tells me? That tells me that the jury disliked the plaintiff's lawyer, that the jury disliked the argument made by the plaintiff's attorney. It told me that there was no credibility, not only with the plaintiff's lawyer, but with the plaintiff's expert, the medical expert who came in to support this particular case on behalf of the injured victim. For the jury to come back so quickly tells me something very significant, that they believed everything that the doctor had said, both doctors, that they believed everything that the doctor's attorney had said, they believed all the proof on behalf of the doctor, and they believed nothing of the plaintiff's attorney. And that is a fatal flaw that I believe that this plaintiff's attorney made and never recognized what he had done and never recognized the flaws that his own expert had and why the jury didn't believe a single thing. Because if they did, now it would have been a real credibility issue where now they're debating which expert they believe. Do they believe the plaintiff's expert, the injured victim's expert, or do they believe the doctor's expert? In this particular case, because they came back so quickly with their verdict, there was no issue whatsoever. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.